judgment, which I had the privilege of representing short class in that matter. My lords, the third issue is the regulatory and the statutory compliances that are mandated on brand owners. With that, I'll start with the SBRT notification to begin with. My lords, it's somewhere in para 2 there of the note itself.
Yes.
My lords, the Government of India issued the press note 2018 on 26th March 2018. I'm just relaying the dates because they will be important, which allowed 100% foreign direct investment in the single brand retail trading. In light of this foreign liberalized policy, Realme launched its phones under its brand in India and commenced selling the mobile phones in India. My lords, the incorporation date of Realme is 25th September 2018. The information is filed about 11 months later on 25th October 2019. The curious case is that OnePlus, which is the other item, was only incorporated on 8th October 2020, which is after the prima facie order was even passed. So it was not even in existence. It was not incorporated. It was not in the market in India. Yet by some degree of imagination, I have come to be made part of this DG report, which has been served on us. My lords, I would also like to mention that the fact that the phones that are made under the brand name of Realme and OnePlus are sold also on my own website and were sold even on my own website, apart from being sold in on Amazon and Flipkart. So they were not exclusively sold both on Amazon and Flipkart. They were also being sold on the online medium of my own website. Apart from my own stores, because I came to India under single brand retail trading, I had to open my own stores. And there is the larger issue of COVID having hit us in 2020, just after I entered the market.
As you say, brick and mortar happened in 2022 December. Your own stores were established in 2022 December?
My lords, my stores were established sometime between 2020 to 2022.
All right, yes.
The brick and mortar stores, but I was selling on the website since the very beginning. So the date on which I made my first sales as Realme is April of 2019.
You did not sell it only through Flipkart or Amazon.
That's right.
You did it from your website.
That's right, my lords.
Then established stores in the 2-year period.
Yes, my lords.
And began to sell through them.
Yes, my lords. My lords, it would be incorrect to state that the members of the Delhi Vyapar Mahasangh are my competitors, which is the informant, because there's a possibility, and I haven't really checked on that per se, but the retailers that I have may also be members of the informant.
Could be.
And therefore, they cannot be my competitors because I'm really a brand and they are resellers. My lords, at this stage, I'd like to first point out the preamble of the Competition Act for a minute, because then it will be useful to come to the short classes judgment and lay the parallel there.
Yes.
My lords, if I may, an act to provide, keeping in view of the economic development of the country. That's the primary action that is tasked to the CCI for establishment of a commission to prevent practices having adverse effect on competition, to promote and sustain competition in markets, to protect the interests of consumers, and to ensure freedom of trade carried on by other participants in markets in India and for matters connected therewith or incidental thereto. My lords, in view of the economic development of the country, the reason why this became important was that SBRT is the crux that led to another level of transformation or development or economic reforms in India, where 100% trading, single brand retail trading was permitted by a foreign owned company, 100% foreign owned company. And that's what led me to establish myself in 2019 and then in case of OnePlus in 2020.
So the drill goes like this. 26/3/2018, the SBRT comes into force. 2019,
18.
2018. 18, the 100% investment.
Yes, ma'am.
2019, Realme comes in.
Yes, my lord.
2020, OnePlus comes in.
Yes, my lord.
2022, Realme gets into OnePlus, and OnePlus is what is existing now.
No,
Is
my
that
lords.
the case?
No, my lords.
Or even
Realme
is-
and OnePlus
All
are two
right,
separate brands.
separately.
Yes, my lords. Yes,
And the prima facie information that comes about in October 2019
that's right, my lords.
was at the time when the OnePlus was not even in existence.
Yes, my lords. And Realme was only 11 months into existence.
Correct.
And therefore, that would mean that the crux or the threshold of 3-4, which was pointed out by Mr. Chandyok, of appreciable adverse effect on competition
Yes.
could not have been there by a company that is only 11 months old into the market of India.
No,
that
you
already
can-
has
you can
players like
always-
Samsung, Apple,
You can always
etc.
come with a bang and create. Yes, that's all right in a lighter way. Yes. Hmm. So
my
according
lords,
to you, 11 months is too nascent a period for any competition to generate. Yes.
yes, my lords, to form an appreciable adverse effect on
Correct.
competition.
I was wondering whether
I didn't see you. Sorry.
being argued on the merits.
Oh, I didn't see your presence. Yes.
I thought the entire matter being argued on the merits of what the commission will ultimately do. We are at an entirely different stage of
Correct.
investigation by the
No,
DG.
that's
No,
why
sir.
the council said she'll argue in the other own way. You can do it. Yes.
Sir, I'm only giving the background, if I may be permitted. My lords, the background is important because I mentioned the regulatory paradigm and the preamble of the Competition Act requires the CCI to be mindful when it forms a prima facie view to think about all of this when it passes that 26(1) order. Now, my lords, I'm coming to para 1 of the short class judgment where the Honorable Supreme Court had taken note of that preamble and therefore starts on that point.
Yes.
My lords, I'm passing the compilation that has the case laws and some parts of the facts as well. My lords, short class is tab A, page 1, para 1.
Yes.
India's economic ascent rests on a delicate but decisive equilibrium. On the one hand, markets must remain contestable. No undertaking may extinguish rivalry by stratagems foreign to fair, merit-based competition. On the other hand, genuine achievement, whether expressed in scale, efficiency, or technological advance, must be rewarded and not punished, for it is the impetus for investment, innovation, and consumer welfare. The Competition Act 2002 is the charter that secures both pledges. It equips the Competition Commission of India with wide-ranging powers of inquiry and remedy, yet it permits intervention only where hard evidence shows that impugned conduct has caused or is likely to cause a demand rigorous fact-finding, adversarial testing of testimony, and above all, an effects-based appraisal. Therefore, the effects have to be shown that balances commercial justification against proven harm. Preserving this symmetry between discipline and encouragement is essential if the statute is to nurture robust rivalry while sustaining the confidence of domestic and global investors who increasingly view India as a premier destination for enterprise and innovation. My lords may take note of para 78 and 79 as well.
You should have indicated paragraphs in the index. Page numbers are there. Paragraphs.
Yes, my lords.
Please indicate the paragraphs and give, so that it will be easier for me.
Yes, my lords. Paragraph 78, 79, and 80 after 1.
I'll give this back. Just indicate the paragraphs afterwards.
I'll do that, my lords. Yes, my lords.
78.
My lord, 78, 79, and 80, apart from para 1.
All right.
Page 51 and page 52.
Yes.
My lords, in terms of shot glass, I'll just give a short background, which is that the product in question was glass vials for pharmaceutical purposes. And
Yes.
Kapoor, which was considered to be my competitor, had alleged that there was refusal to deal and the discount policy was anti-competitive by shot glass.
Yes.
My refusal was based on IP violation and espionage of Kapoor Glass, which is noted in the order.
Yes.
But the court takes note in para 78, if my lord has para 78.
I'm there.
Competition law is not designed to humble the successful or to clip the wings of enterprises that have, through industry and innovation, secured a commanding share of the market. The true purpose of antitrust laws is to preserve the process of competition, that is to ensure that rivals may challenge the incumbent on merits, that consumers enjoy the fruits of efficiency, and that technological progress is not stifled by artificial barriers. If mere size or success were treated as an offense, and every dominant enterprise exposed to sanction without tangible proof of competition harm, the law would defeat itself. It would freeze capital formation, penalize productivity, and ultimately impoverish the very public it is meant to protect. My lord, 79. In today's economic global climate, prudence is vital. As the United States and Europe retreat behind their newly minted trade walls of protectionist policies to shield their homegrown markets, India's bid to emerge as a global center for manufacturing, life sciences, and technology will succeed only if regulation rewards scale and intervenes solely when genuine competitive harm is shown. Heavy-handed enforcement, divorced from market effects, would discourage the long-term capital and expertise the economy urgently needs. An effects-based standard is therefore not a procedural nicety. It is both a constitutional bulwark against arbitrary restraint of lawful enterprise and a strategic necessity if India is to capture the opportunities that more protectionist economies are in danger of forsaking. My lords, finally in para 80, it was the Supreme Court had taken note that Kapoor Glass had litigated
Yes.
on a prolonged basis and therefore imposed a penalty, increased the penalty from 1 lakh rupees to 5 lakh rupees.
Yes.
The cost of 1 lakh rupees to 5 lakh rupees. My lords would also take note that this finding in para 1 and 78 and 79 came to be found because the preamble was pointed out and also because the court took notice that short glass had entered India in 1998 after the liberalization policy in India of 1995. So it took note of that, and that's why I gave these,
Yes.
noted these points.
Yes.
My lords, it's also important to note that CCI's decisional practice has not really gone against the idea of each enterprise themselves deciding their business practices and who to appoint as dealers, distributors, etc. So there are a few cases that are part of the compilation.
Yes.
One is Hive Loop.
4 cases.
Yes, my lords. It's tab B, my lords. Hive Loop, para 51.
B to E.
B
is
to
the-
D, my lords.
B to D. E is the judgment.
Yes, my lords.
Mm.
B to D. Hive Loop is the first one. It is an order passed by the Commission itself in 2022, where it says nobody can seek an absolute right to deal, and even dominant enterprises have freedom to conclude contracts based on objective justifications. Basically, not force enterprises to appoint everyone and to deal with everyone if their business case is not made. And therefore, I'm connecting it back to the time when I just came into India. I could not have set up so many brick and mortar stores. It would take me time to scale up, and therefore to say and hold that against me at that point in time when the law and the regulatory regime did not require me to do so would be entirely unfair and unjustified and arbitrary on the part of the CCI and the DG both. My lords, similar is the case of C and D, as my lords has already noted.
Yes.
That, and paras 52 in C for tab C, I'll try and go faster.
No problem. Yes.
My lords, it's page 110 of tab C. It's Hexa Communication Private Limited versus Atos India Private Limited. It's again a judgment of June 2022. And the CCI itself notes, in relation to the allegation of the informant that the opposite party does not warrant any service and support in respect of its products in India as provided by the informant, the Commission is of the view that a manufacturer has no legal obligation to warrant genuineness of products, spares, services offered outside its distribution channel, and any insistence that the same be bought from its authorized distribution partners in itself cannot prima facie be considered abusive or exclusionary. The Competition Commission notes the rights available to a manufacturer to protect the sanctity of its distribution channel and its goodwill in relation to the goods or services offered under its brand names. My lords, the same is the case, and it starts since 2014. The reason why I've not given all cases but given a spectrum, the Competition Act it came into force in 2009. So as long as from 2014 till about 2022, CCI has held this decisional practice that we are permitted as manufacturers to have a say into deciding who we want to appoint as distributors. And today the Supreme Court has made it clear that unless the effects have been proven to be harmful, and there is nothing in the prima facie order that also says so per se, that they have found an effect, even to make a prima facie finding on that, there isn't any. They say we will have to investigate to find out if there is appreciable adverse effect. And I'll go into that also, my lords. My lords, my competitor are all mobile phone companies and mobile phone brands. Why will a company or a brand that is entering India not want to make more sales? It doesn't make a business case. If I don't want to sell more mobile phones, I would want to sell it, but not at the cost of both commercial sense, objective justifications that my business requires in terms of scale, and the overall intellectual property rights that I am required to protect because I am working under licenses. There's also a larger issue, my lords, with respect to the regulatory regime, which is that mobile brands have to adhere to something called an IMEI code.
Correct.
All mobile companies have to have that. And
Yes.
therefore, every trader and every small shop cannot be granted the phones because there is the large gray market that is known to exist with respect to mobile phones. And a huge security concern ever since 2020 has been found by the government of India, which they keep sensitizing all mobile brands on, that these IMEI codes, and we are supposed to report to the government agencies in terms of each of the IMEI codes also. So there's that regulatory
But this-
aspect.
When asked,
When asked, we have to keep a list, maintain that list, and whenever asked, we have to supply those.
now next is Snapdeal SanDisk.
Yes, my lords.